252. Yeah. Now, I just asked the question, what happens when a judge can't hold you in contempt? Well, the county said that it was my responsibility to go to the court clerk, yes, and pay 50 cents a page to get a copy of the dissolution of marriage. Yeah. That is not my responsibility. Oops. My responsibility was to respond to the summons. Yeah. And then your obligation, right, was to serve me before having court hearings. Now, for every judge of the United States of America that issues a court order, yes, to either of the parties, that being the petitioner or the respondent, yes, the plaintiff or the defendant, there is this obligation to enforce the authority of a judge to hold you in contempt. Yeah. Now, a lot of individuals, right, even as the plaintiff or the petitioner, you would think, well, they can't be held in contempt of court right now. Now, can the judge hold the petitioner in contempt of court? Well, she didn't serve me. There's a big concern that there is no actual authority of the judicial system of the United States. Yes. See, there's this thought, right? Valid court order. Yes. Has certain regulations of the state of Washington to be valid. Yeah. And it requires actual due process for that to take place. Now, I'm telling you that there is no proof on the public court record, right, that Paul Budnick was served a dissolution of marriage. It's not that, well, it doesn't matter, right? It's not that we're going to get him for back child support. Yes. You have effectively removed the authority of the judicial system of the United States from this court in Clallam County to every county court in the state of Washington. Yes. To every court in every state of the United States. Yes. That has the full faith and credit of the acts, records, and proceeds. Right. To all international courts of the world that would have an obligation to enforce the conditions of the decree of dissolution of marriage. The Washington State Court public record does show, yes, that Paul C. Budnick, as the respondent, was not served. Now, for the Hague Convention, yeah, I was not served. Yes. It actually says that mail returned unclaimed. Yeah. The decree of dissolution of marriage, yes. I cannot be contempted for violating any of it, yes, because you did not serve me. That means in every state of the United States, if I was to move, yes, and a judge said, well, give me a copy of the dissolution of marriage, yes, you cannot enforce a child support order by contempt. Oh, even after the child is an adult, unless back due support has been paid in full. RCW 26.18.050. Oh, in regards to the marriage of Humphreys, 79 WNAP 596. Yes. Now, there's this idea, right? I owe child support because you issued a decree of dissolution of marriage. Yep. You say it's a valid court order, even though you didn't give me any due process, Mr. Baisden. Yeah. The public record shows that you issued a decree of dissolution of marriage. Yes. But the factual, plain, non-violating of the decree of dissolution of marriage, because there's no proof of service in the public court record. Now, a notice of the contempt of hearing and a chance to be heard have been given. That's not in the public court record. No. Contempt cannot be an appropriate remedy for the violating of the decree of dissolution of marriage because the public court record shows on February 13th of 2012 that the mail was returned unclaimed. Now, I don't think it was the actual decree of dissolution of marriage, yes, but it does show that this court has effectively removed the authority of the jurisdiction of the United States of America from every state of the United States territory and possession of this nation. Yes. Now, I just wanted you to understand, yeah, the authority of a judge to contempt somebody who is as important or maybe more important than the signing of a court order. Yes. Now, judges seem to have thought, yes, that it was more important to sign the order. Yes. Brent Basden. Yeah. Ex officio Superior Court clerk. Right. Than the availability of finding somebody in contempt of the court order. The actual authority of law to issue a court order is not, yes, the signing of the order. It's the availability of finding an individual in contempt of the court order. That's where the real authority of the court shows up right now. Now, you, the court, do not have the availability of enforcing the child support order. Yes. By contempt, even after my sons have, after they're adults. Yes. Now, this is something very disconcerting to myself. Yes. I would want you to be able to get child support until they're 50 years old. But without the availability of contempting the court order,